Mr. Marcello, you spoke of the Faulkner Act, and I know obviously we operate under a special charter. How many other municipalities within the state of New Jersey operate the same way that we do, in which a layout plan has to be submitted to the city council for approval?
Well, under a Faulkner Act, none. Absolutely none. Under any Faulkner Act form of government, the administration could unilaterally present a layout plan, assuming it's a civil service municipality, to the Civil Service Commission for approval. Okay? So, in other forms of government, that situation is different, but under a Faulkner Act, which is the one that we mirror most closely, the action would be taken solely by the administration in every instance.
Mr. Marcello, you used the word stray. How did we get here? How did that happen?
I honestly, I cannot, I do not have an understanding of why this ordinance was originally approved by the governing body. It's been in place for quite some time. But a clear reading of our charter versus our code, this doesn't really gel. So we thought it was incumbent on us to make sure that our ordinances comply with our charter. Yeah, and Council President, if I may just add one other instance, this is not the first time we've had an instance where our code hasn't complied with our charter. As some council members may recall, we had litigation between the mayor and a prior city council regarding PMUA appointments. Just a refresher for those who weren't there, the PMUA, the code provision with regard to appointments to PARSA, required that the mayor make that appointment, but that it must be the executive director of the PMUA. The mayor took legal action to say, that's an infringement upon my appointment power. I have the right under our charter to appoint someone subject to advice and consent of the council. You can't put restrictions on my appointment power. That went to court, the mayor versus the council, and ultimately the mayor won that case on the idea that they were not able to restrict the mayor's appointment power. And ultimately our code was found to be invalid with our charter. This is a similar instance. We're restricting the removal power of the mayor on the flip side, and we're attempting to come into compliance here.
How would you compare this to other municipalities, Mr. Marcello?
Well, as I said, I mean, under a Faulkner Act form of government, there is no analogous relationship between the mayor and council. It's always been an administrative function for the council. For the administrative function for layoffs to be handled, and not a council function.
Any other questions?
Yes. So I can appreciate how we seem to be one of the only municipalities who the power of submitting a layoff plan rests in the council. And we're seeking to change that today. The fact is, at this point, the council does have that power, and to vote on that would be, could be considered a relinquishment of that power, or it could be considered simply shifting the responsibility of this on the mayor or the administration, depending on how you look at it. But I think what most people seem to be concerned about is it being used as retaliation, or there being some type of retribution if they don't align themselves politically. So what I would like to see in an ordinance is just something that enumerates protections for individuals. Perhaps maybe some type of three-pronged test that says it needs to be non-biased, or there's no political retribution. Something that just gives people some comfort that that it's not done arbitrarily, because I think that's what people are worried about, just arbitrarily being fired. Is it possible that maybe there could be just some added language that provides protection against arbitrary layoffs?
Councilman, to your question, the New Jersey State Civil Service law specifically provides the protections that you're calling for. Specifically, any employee who feels that they were the victim of political retaliation can bring that as the basis for the appeal, to say that it was not done in good faith, not done for reasons of economy and efficiency, and done for political retribution. So, that is the standard that every employee in the city of Plainfield, by virtue of being civil service, has those protections in place as we speak. And by virtue of our code requiring that we are civil service, every employee is afforded those rights.
And I should add, Mr. Vice President, there's nothing to stop any employee from making that accusation today, now that you, the council, has the authority to say yea or nay. So if you were to say nay, yea, under the present situation, there's nothing to prevent an employee from accusing you of political retaliation. So it works the same way regardless of which branch of government makes the decision. And the point that we have made and that Mr. Minchello made is that in part of his explanation, people are talking about you giving up power. It's really about the separation of powers. And the function that we're talking about under the charter is an administrative function. So it is not that the council is giving up its power, it's the alignment of the separation of powers. And that's really the administration, or how we see it. Thank you.
Any other questions?
I have another question.
Who did that? Yours? Yes, we'll go from one end to the other. Councilwoman Davis.
So I have a few questions. The first one, you said that employees will have the right to appeal. Does that appeal process start before the layoff has actually happened, after the layoff has happened, or during that layoff process?
No, once a layoff takes effect, an employee may file with the State Civil Service Commission.
Okay, so this is after they've already.
Yeah, exactly. There has to be some action taken against them before, or you have to be removed from the position or to eventually.
Okay, so my next question is about the timing of the ordinance. So we just approved at last month's meeting, I believe, a number of changes to the code to be in line with the special charter. Is the administration going to come back in the future with more changes? Like, how are we finding these changes to this that need to align with the special charter that we haven't found already?
Well, I think this one's a little different. I think what we had the first time around was based on our new charter, we had a reorganization of all of the departments, and that was the first large reorganization that's happened in 30 plus years. In that process, though, many individuals came forward and raised concerns about positions that existed, and were concerned that this may bloat government. So we went back and took out all of those positions that the administration believed were no longer in use. Every department had went through their specific provisions in the code and took out positions that were no longer in use. This one is a little different only in that this one raises questions of the separation of powers. And, as we continue to come across code provisions that we feel aren't in line with the charter, we'll certainly bring them to your attention. Do we have another one coming out? No, we do not have anything currently that we see that is in violation. But this one specifically, we thought would require the council's attention.
Okay, and also I think to Councilman Hockney's question, how do we assure the public that future administrations will not have layoffs just because when they come in?
Well, yeah, obviously, I'll say it again, being that we are a civil service municipality, many additional rights are afforded to our employees that are not afforded to employees in non-civil service municipalities. So things such as tenure, things such as promotional rights, the calling of tests as opposed to just promotions being made without any criteria, layoffs, there are protections for all of these that you are granted by the state. And those will remain in effect and will not be touched because we are a civil service municipality. And there's no intention to see it to go in any other direction.
Thank you.
Is that one other question?
Councilman